So now you've been, fair use the content for something else that is, it was designed for. Don't be greedy, you said, and you said also that people are using fair use. But if you could put that into a context of what you just heard from Leistner, from the German perspective, and also the European perspective, what do you think then?
I think that I should listen to Europeans about a European perspective.
Yeah, but what I'm thinking is, as I was been told, the contracts in the States are often that thick between publishers and authors. So don't you have isn't there an uncertainty there in the law that you have these big contracts because you have to describe everything, as I understand it, or is?
So are you saying, are you talking particularly about publishing?
Yeah.
So you're saying, is fair use available to authors and publishers?
Yeah.
It's not only available, it's very widely used.
Okay.
I wrote a book with my colleague, Peter Yassi, called Reclaiming Fair Use, making it easier for ordinary people to understand fair use. And the editor-in-chief of Oxford University Press wrote me a thank you note, and he said, really, all of our authors need to understand this more clearly. So definitely publishers use this. All large media actively and vigorously employ fair use because it's very good for them. There are international contracts sometimes written that say you're responsible for getting all the clearances. And what authors frequently do, and this has been a point in the codes of best practices, is to return to the publishers and say, actually, I know that, but I don't need clearances here because I'm employing it under fair use. Sometimes this involves a conversation. It may be the first time that a publisher has actually had that conversation, but typically it works very well. We have examples of Cambridge University Press not only agreeing with an author to change their contract to be able to use fair use, but change their policy. The University of Chicago Press is routinely publishing books that could not be published if they did not do fair use. For instance, an entire book on ephemeral political art of the 1970s, a lot of which is orphan works. So I think that it's widely employed.
Okay, would you like to comment on that, Rosenmeier?
But I think that many European copyright lawyers believe that our system with specific provisions on what you can do and cannot are better than the fair use system because the latter is so abstract and leaves so many questions open that you have to make contracts this thick because you don't trust the fair use principle. Is that a fair thing to believe?
Well, boilerplate contracts seem to be very common everywhere, but the boilerplate contracts are not extensive because of fair use. That's not their issue. They don't even deal with it because it's fair use is not contractual. It's outside of contracts. So I've certainly published with international and national publishers, and I think they all love their boilerplate contracts, but most of those terms have nothing to do with this.
Dr. Leistner?
And I think what Patricia says is very interesting for our current discussion in Europe on both the European and the national level. Let me give you the example from Germany. At the moment, we have a conservative liberal government in Germany, in particular a federal minister of justice who comes from the Social Democrats and is perfectly willing to liberalize copyright law in the field of research and study-related exceptions with regard to the digital challenge. So what do they propose? We still don't know, we don't have the text, but we have heard what they might propose under the umbrella of the InfoSoc directive. And what they propose is broadening these closed shop catalog of exceptions by a newly structured catalog of 8 research and study-related exceptions with no opening clause at all. Now, from my point of view, that is dangerous for exactly the reasons which Patricia mentioned. You're basically freezing the status quo of technology at the moment. You're looking into this, you're trying to designate 8 very specific, very functional and use-oriented exceptions, and then you think you've done the job. But this is exactly freezing a certain status of law. And now what is the reason why they do that? I think the reason why this is done in continental European countries very often is not only some fundamental rights issues of legal certainty, it is specifically because we have these remuneration systems administered by collecting societies. And these collecting societies want to know certainly when their claim to remuneration is triggered. And that's why they argue we can't use these open clauses. In these cases, we don't know whether remuneration is triggered or not. And I think a possible solution to this problem would be to have, of course, these catalogized exceptions. That's fine, it's better than having nothing. And then having carefully limited opening clauses where publishers, authors, and collecting societies, under certain limits in a regulated way, can basically negotiate which further uses to cover under these exceptions. And that would be a possible solution, because on the one hand, you would have the opening umbrella clause, which frees imagination. And on the other hand, you would have certainty within these limits that a solution with regard to collective remuneration can be negotiated in the end of the day. And I think the main reason for the moment being that Europeans, in particular national legislators, are often so skeptic towards fair use, is that they want to provide legal certainty for the collective rights management organizations. Plus, of course, the picture is not a black and white picture. As we have seen, fair use is structured in a rather legally certain way. And by contrast, our research-related exceptions contain so many terms which are subject to interpretation that, of course, they offer certain flexibilities already. But I share the view that this isn't sufficient. It isn't a black and white picture, but certainly Europe is too dark gray at the moment in that regard.
And white, as you said. We'll take questions now if anyone wants to ask questions. We have, I see there's a gentleman there.
Jan Andresen. I think the first, at least the very first talk by Morten exemplified what the typical view of a lawyer is. Create rules, restrict other people's actions one way or another. Have you, any of you, considered turning the system upside down so that instead of making everything illegal, and you have to make exceptions for a few items, instead say, everything that's out there is available. That's the way it has been for not only centuries, but millennia. That's how civilization has advanced. Anything that somebody thought of was the basis of somebody else's advancement. The rules we have now are exactly as you say, freezing the situation at the time when people thought of the rules. For example, there's really no logical reason why there should be different rules for between analog and digital start copying and storage, and whatever we will have in the future. So therefore, I would much prefer to give a try at saying that everything that's out there is available, except if, for example, if you use it to make a profit for your company. So that only the restriction part will be the exception. The rules that we are having here in Europe now are really tailored entirely to make sure that publishers and similar companies have assurance of a hefty profit based on free deliveries from the scientists, as the welcoming address explained. So in my mind, it's the whole idea, the whole structure of the copyright free access thing, which is erroneous. it must be turned upside down. Because basically, whether the rules are there or not, we are going to do the data mining. Somebody's going to do. So you can set up rules, but they're not necessarily followed.
Yes, and your question being, can it be turned
Can
upside
you imagine a system where things are turned upside down?
Yeah, okay, please. Who would like to answer? Yeah, Rosenmeier, Morten Rosenmeier.
I can well imagine the system being turned upside down, but the question is, what will happen then? For example, the reason why it is doubtful whether TDM into scientific journals may be a copyright infringement is, of course, that it costs a lot of money to publish scientific journals, and if that is the idea behind it anyway. If it was, they could, if everything was out in open access totally, and every sort of non-commercial use of protected material was allowed, then the fear is that that would sort of harm the economic structure of the present system, and this would again, it is believed, lead to the creation of less research and less works and so on. So it is rather a difficult problem, I suppose.
Professor of the Aufderheide, you were talking about the mind being shackled by the law. What do you think, if you had to comment on the question here?
So I think it would be possible to enter into a discussion about what we would call in the United States the copyleft perspective, sort of the hell with copyright. But
to hell with copyright?
But I think that by and large this community is having a different conversation. I agree with you that copyright is relatively new in the history of humankind. And I personally believe that copyright is unbalanced, that it prioritizes copyright monopolies in a way that makes that privileges existing culture and limits in a way that nobody probably expected the creation of new culture. And I think that has happened largely because there are large interests invested in existing culture. All collecting societies are really invested in existing culture, and they do an excellent job of representing their positions. A lot of emerging or new culture is unrepresented by anyone, partly because it does not exist yet and can't exist yet, partly because some of those voices are less well-funded. But the copyright's core logic is that it's supposed to encourage people to make culture and reward people who make culture and encourage people to make culture. Both of those things should happen if you really want more culture. So this is where I think the voices of people in libraries, in research institutions, scholars, people who work in think tanks, people who have some perspective, and also legislators and regulators who should be concerned about the future as well as the present, who have an understanding of the public interest as involving both. Those voices also need to be present to establish a reasoned approach. The reason why I don't think much about what would happen if we turned everything upside down is I just don't think that's the world we will either live in or will live in, and I want to live in the best world that I can, that I have.
Okay, that's nice to know. Rosenmeier, you didn't have any questions. Okay, I'll ask you then. If there's anyone else, we'll take more questions here. There's a question here.
So, Michael Elbæk, Technical University of Denmark. So just a short question. From a layman's perspective, it seems that the FAIR principles are quite easy to understand, and you mentioned that it enables people to do things they want to do, they understand how it works. Is that any consideration in the European lawmaking process that you do something that is understandable by lay people and not just by lawyers.
Not just by lawyers. Leistner.
That is a brilliant question. And for example, the German legislator just considered of whether a school teacher should know what's in the Copyright Act. Actually, from my point of view, it's a complicated picture. I mean, in most areas of law, laymen do no longer understand what the law means. You probably wouldn't even know what the law means in family law when you get a divorce or something. I think the paths along which law works are a little bit different. So basically, it's experts specifying it further and boiling it down to certain basic principles, and then people just act as along certain paths, and it works in an indirect way. But of course, we should designate law in a way that it doesn't have considerable chilling effects. So if, for example, under the rather broad umbrella of fair use, a university chancellor wouldn't know anymore of which uses are possible and which aren't, we would have a problem, and a problem that can be solved by research projects such as Yazi's and Aufderheide research projects. In European law, when you look into these exceptions, at least under the Information Society Directive, you would probably understand them. But then the European Court of Justice comes in and goes specifying them in case law, and that brings additional problems. So in the end of the day, I think your question basically is another argument towards a certain flexibilization, to designate exceptions along the line of certain functional uses, instead relying upon a definition which tries to connect to certain technology. But then even if you take all this into account, I think we have to be rather cautious. The system will never be really understandable to a layman. What we can hope for is that it is understandable to the administrative people, and that they then carry out it in an efficient way. But that the man on the Clapham omnibus is going to understand the system of copyright exceptions specified by the courts, I think that will never be a realistic perspective. It might be better, but it's just too complicated.
Okay, we can take one more question, if there's any. There's one there.
Else Marie Bartels from the Parker Institute. I think the whole problem has come because when I started out as a very young researcher for several years, I never gave away my copyright in biophysics and physiology and biochemistry. But then suddenly, of course, we can all reproduce. And the other thing, the knowledge, information, the amount of published paper has grown to something nobody can comprehend. You can't even cover your own field, even if you try hard. And that's where the whole problem lies, and that's where we need the laws, because I've been caught out with an old professor I helped with a book that we used to be able to use our own graphs. You just had to refer to it. There was a sort of gentleman, gentlewoman agreement that if you used the Friends graphs, you were actually allowed, but you would write to them. But today, the journal would say, oh no, your paper from, I don't know, 90, it is now copyright under us, although you never gave away your copyright. And there's no really legal thing about it. But the other journal, because you never gave away your copyright and you used to have it. And you could use it in textbooks or for your students, and you could use your friends, and it was more you asked them. But now you're caught out, because if I then want to publish a book, say Cambridge University Press or something, they would say, oh, we need to pay or ask if we can use that from the other firm, basically.
So your question being?
My question is, how do we solve it? Because I think we've just all been taken with the trousers down.
All right, okay.
Because it was something that was actually structured and internationally solved, and then suddenly we can all reproduce, put it on the internet, take each other's data.
Okay.
And I think that's where all the
It's a rather big question, and we'll be looking into it later today, but I'll ask the panel here. Any comments on the question here? Yeah, Leistner?
And I think it links up to your question of whether we should just turn around the system fundamentally. And I agree with the other speakers that internationally at the moment this wouldn't be possible and we wouldn't be able to do this, because when we did without copyright for centuries, of course we had alternative financing mechanisms. It was basically the king paying, or whoever was a ruler in the country paying. So it was based on a public financing system. And that brings me back to the question of whether there should be certain pockets in copyright law for certain specific areas, at least, where copyright law should really be much more lenient.
And we'll be looking into that later today.
And indeed, research might be one of these cases.
Yeah.
Because there you have that heavy financing from public authorities. And here you would probably need more open access in the end of the day. And we have certain pockets for it. But of course, at the moment, that's very limited approaches. It's just pockets within the exclusive rights system. But then again, with all these public financing systems, you will run into the problem of how to distribute the money. Because at one point in history, we all agreed that it would be the markets who did it best. And for this, we need the property rights. So then you will always be under a certain justification pressure of which bodies should distribute the money in such a publicly financed open access system, and whether that is really more efficient than what we have now.
Okay, well, so far, so good. One brief for you, Aufderheide.
So, first of all, let me point out that there are many cases where both sharing information and making it available in the US is clearly done with no problem with fair use. And in the US, the assumption is not that every single possible cent should be captured by the original author, that there are some uses for which the author should not be compensated. But second, I want to commend journals, commercial journals, for responding to some degree to the open access movement, which has really opened up some possibilities, because many commercial journals allow their authors to publish preprints in places such as academia.edu, ResearchGate, SSRN, and so on. Some journals, such as Sage, make some of their material openly available after 6 months. So there is a kind of accommodation going on within the commercial field, which is also a response to a changing digital environment and public pressure for open access.
Okay, this was our first discussion. I think we should give the three professors a warm round of applause. Thank you so much. The three professors, it sounds like a fairy tale.